Welcome to pretrial justice in the state courts. I want to introduce
why
to
don't
you
we stay standing while he's introducing us?
Sue Ferrere. She is the technical assistance manager at the Pretrial Justice Institute. The institute is located in Maryland, but she works out of Evergreen, Colorado. Chilly today, I think. She also worked on the Colorado pretrial assessment tool and has specialized in therapeutic jurisprudence. Most of us know Susan Keilitz, principal research consultant at the National Center for State Courts. For 25 years, she has been working on policy responses to domestic violence and has assisted in developing the resources for the pretrial justice, and then Bettye King, court administrator and clerk of the court for the Birmingham, Alabama Municipal Court. She's also vice president of the Alabama Municipal Court Clerks Association, has her master's from Auburn, go Tigers, and her Juris Doctor from the Jones School of Law. So, ladies, it's yours.
Thank you.
Thank you, Peter. I thought that was going to be my job, so things have gotten easier already. I do want to thank you on behalf of the panel for my esteemed colleagues, not the panel. We had a really nice dinner last night and got to know each other, and I'm very impressed with the work that these folks are doing for pretrial justice reform. And I'm kind of the newbie to it. I've been working on it for probably almost 5 years, but these folks are veterans, and so I think we're going to hear a lot of good information about what they've done. Sue's going to start us off with a discussion of the landscape of pretrial justice reform across the country and why it's needed, some of the research and other forces that are driving the need for reform. And then I'm going to focus us back on the project that SJI is funding, which is pretrial justice for courts, for the state courts, and efforts that have been implemented across the country under the auspices of that program. But first, we're going to hear from Sue.
Can you hear me? Yeah. Great. All right. So good morning, everyone. Thank you for joining us in this session. I'm going to kick us off by just talking about the landscape of pretrial justice across America, tell you a little bit about what my organization does, and some of the central issues in pretrial justice at this point in time. So I come from the Pretrial Justice Institute, or PJI, and we have been around about 40 years, and we do technical assistance to jurisdictions that are wishing to improve their pretrial justice systems, moving to more legal and evidence-based practices. We also provide advocacy for the movement and education. So who here has been seeing, reading stuff about pretrial justice or bail reform in the headlines? Yeah, okay. So this, and who is from a jurisdiction that's actually doing some pretrial justice reform? Excellent. All right. So this is just a small sampling of some of the headlines from the last week or so. This is out of Dallas. Lawsuit challenges bail system, claiming it jails people for being poor. This is out of Ohio. So that everyone gets a fair shot, court administrator says, of need for bail reform. And the quote is from the Supreme Court chief from Ohio. Hawaii bail study, this is a study commissioned by the ACLU, finds justice is what you can afford. Oops. Unsafe and unfair and unsafe. Even prosecutors want to end the money bail system here in California. And then finally out of Georgia, Atlantans await city council vote to end cash bail. And again, this is just a small sampling of the headlines that are screeching across all our media sources recently. And in addition, besides kind of mainstream media, we have a lot of pop culture talking about bail reform now. If anyone has seen the John Oliver video, you could just Google John Oliver and bail. It's a really brilliant and hilarious and very common sense kind of take on our bail system. So I highly recommend you checking that out if you haven't already. We have football stars and entertainers coming into this movement and starting to speak to the need for bail reform. So why is this groundswell happening right now? What is kind of all of the forces at play here, putting pressure on our pretrial justice system to change? One is legislation. So numerous states have embarked on changing their pretrial justice statutes and the Constitution. Most notably, New Jersey really did a complete overhaul of, they were a state that relied solely on commercial sureties as their mechanism of release, and they've moved almost completely to using pretrial assessment and a pretrial services mechanism for releasing individuals. And this came about by changing their constitution and changing their statute. And they're just probably the most high-profile example, but this is happening all over the country, discussions about changing the legislation. And in addition, what's really neat is it's becoming bipartisan. So, kind of the liberals come to it from the social justice argument, but also conservatives are coming to it from the notion of if you curtail someone's liberty, that's about the biggest affront to the American system and what we think of in terms of our liberty rights. And so just as an indicator of that, Kamala Harris out of California and Rand Paul have actually put some federal legislation forward to support states who want to improve their pretrial justice systems. I'm going to pair these two. There's a lot of social activism around improving pretrial justice practices because we're recognizing that the pretrial justice system as we know it, which is primarily money-based, has a disparate impact on people of color and on people who are on the margins of society. And there's really been a recognition of that in the criminal justice system in general. But the pretrial point is a place where those disparities are further accelerated or concentrated. And then this also fits into our decarceration movement, which is both being led by social activism, but also within the system. I mean, many places are talking about reducing the number of people they have in their jails. And when we talk about incarceration in America, the problem now is mainly in our jails. On any one day, we have 650,000 or so people in jail who have not been convicted of a crime. Litigation is also driving this. It's driving it pretty hard. So organizations like the ACLU, Southern Poverty Law Center, and an organization called Equal Justice Under Law are suing jurisdictions that use money bail systems, and they're usually class action lawsuits representing people who are being held in jail because they cannot pay a money bond. And they're not just suing the jurisdictions, they're suing the individual office heads too. You've probably heard of the case in Harris County, Texas, which has gotten a lot of play. And the cases are being brought, and they're closely related to the fines and fees cases, which are also being brought by these organizations, but they're being brought on equal protection grounds, the 14th Amendment, which is an interesting, but the more you look at it, a real appropriate place to bring these kind of claims. Then there are resolutions. So organizations, membership organizations within all spheres of the criminal justice system have come out with resolutions supporting the use of pretrial assessment and de-emphasizing the use of money as a condition of release. There's all kinds of research that's also kind of pouring in and supporting a lot of the legal approaches to doing pretrial justice. So they're really kind of working hand in hand to bring this issue to the fore. And then finally, there's a lot of funding pouring in. There was a lot of, Eric Holder had convened a group about 7 years ago now, and that spurred the US government to put some funding into it. And then there have been numerous groups, again, kind of social activist groups and foundations that are really pouring money into this system, into improving pretrial justice, recognizing the impacts that our pretrial practices have on individuals. And then we have some high-profile cases, and this is really just a euphemism for tragedies. One being, for example, Khalif Browder, who was held for 3 years. He was arrested when he was 16, held for 3 years without being brought to trial. And then subsequently, within the few years after his release, he committed suicide, many believe, because of the deterioration in his mental health during that period of time that he was held. And then we also have the cases you hear about where very wealthy people are able to buy their way out even though they've been charged with very heinous crimes, hold themselves up in their New York penthouse with their own kind of home detention and security. And that's best, I just like this quote. This comes from Chief Justice Rabner out of New Jersey. Problems at both ends. This just really sums it up. So New Jersey, before they changed their statutes and their constitution, they undertook a several-year study to see how their system was working. And this is what he said. So nearly half of the high-risk defendants were released pending trial because they could buy their way out. And at the other end, we had low-risk nonviolent defendants who were in jail but for their ability to pay a monetary bond. And when we talk about pretrial justice, a good pretrial justice system, we talk about balancing the 3 M's. We want to maximize court appearance. You want to release people and you want them to come back for their court date. We want to maximize public safety. We want to be thoughtful about who we release and under what conditions so that they potentially don't commit a crime while they're released. And we want to maximize release because that's what our statutes say, that release is the norm, and case law says release is the norm. And we need to do these 3 things simultaneously. It's like a 3-legged stool. So if one is out of balance, the stool it doesn't work anymore. So it'd be really easy to maximize court appearance by keeping everyone in. It'd be really easy to maximize release by letting everyone out. We kind of have to find that nice place in between that balances all of these aims. So these are the central legal principles of pretrial justice, and particularly the bail decision. They come from our constitutional principles and have played out in case law. The first is the limited purpose of the bail decision. So the pretrial period is not the time to fix someone. It has a limited purpose. It has a limited time frame. And so you need to be very cognizant that the decisions you make have to do with court appearance and public safety. Those are the only 2 legally valid guides for making that decision. Secondly, individualized decision making. And Justice Jackson, in a case in the 50s, Stack versus Boyle, which was about this principle, said every defendant stands before the bar of justice as an individual. There can't be some kind of recipe or rubber stamping of release. For example, a bond schedule where you just look at the charge and the number. You know, one person with that charge is very different from another person with that charge. So these things violate the notion of individualized decision making. Release is the norm. This comes directly from the Salerno opinion, and Chief Justice Rehnquist said, in our society, release is the norm, detention is the carefully limited exception. And I'd argue that that's really not what we've got going on in America. We do not have detention being the carefully limited exception right now. And then there's the principle of excessiveness and least restrictive related to the Eighth Amendment. And that just means you can't do more than what you need to or ask a person to agree to conditions that are more than what is necessary to get them back to court, keep them out of trouble. And then finally, of course, or almost to the end here, the principle that you're presumed innocent at this stage. You cannot punish someone, you cannot have conditions that punish someone during the pretrial stage. And then finally, equal protection is just really an emerging argument. It's winning in the courts around the country, and these organizations are strategizing and moving through different states with their lawsuits. And their lawsuits are based on the fact that everybody is entitled to the same protection of the laws. And so if I can pay a bond and get out, and this person looks just like me in what they've been charged with and what their assessment says, and I can buy my way out and she can't, then that violates our equal protection. So PJI does technical assistance. I won't read through all these, but the kinds of things we do with jurisdictions are maybe you want to just get educated on pretrial justice, educate your stakeholders. We do trainings, either on-site or via webcasts. We can give you guidance on choosing and implementing a pretrial assessment. Sometimes if you're at the very beginning of things, we can help convene a stakeholder group to start talking about pretrial justice. And we'll talk a little bit more about the types of technical assistance we provided deeper in this session. One of our initiatives is called 3 Days Count, and this is where states step up and agree to make pretrial justice improvements, and they receive some light TA from us. And the reason we call it 3 Days Count is because we know now from the research that if you keep someone in jail even just for 3 days, it kind of starts after 1 day, particularly if they're low risk and do not need to be in jail, we harm them. We make them more likely to not show up for court and more likely to be arrested for another crime. So we do precisely what we're trying to keep them from doing if we detain them unnecessarily. So these are the three aims that states commit to if they join 3 Days Count. And I want to just mention the first one, which is reduce unnecessary arrests that destabilize families and communities. This is kind of an underutilized pretrial justice strategy. A lot of what you're seeing is about bail reform, about kind of getting money out of the system. But if you start thinking about pretrial justice, you want to make sure you think even earlier than that. So does everybody that gets arrested and booked into your jail, do they really need to be arrested, booked? Can you cite and release? Can you do something completely different, like deflect them? So that's really the place to start before you start what might be the heavier lift, which is talking about what you're going to do at that bail decision and changing some of those practices. And then finally, I just want to mention, if you wanted to embark on some self-learning, we have the University of Pretrial. It's both a learning and discussion community. So we have all kinds of events. We have coursework. The vast majority of the content is free. And we have the best pretrial library out there, and it's updated constantly with a lot of the new cases and the research that's coming out. And then the community, it's a quite active community where you can ask questions of other practitioners around the country. So I encourage you to join us on the University of Pretrial and sign up.
Thank you, Sue. I'll be talking a little bit about that as we pass. And we have to. So you can see why the Pretrial Justice Institute, which do I hit, the green?
To advance it?
Yeah. There we go. The State Justice Institute, as many of you know, has several different initiatives and priorities that it's funded over the years. And because of the great movement and momentum in the state courts to engage in pretrial justice reform, the State Justice Institute decided that they would like to support this effort and put their resources into it in a timely fashion while everybody is getting very interested in doing something and moving forward. And so they asked the National Center and the Pretrial Justice Institute to partner, and that's what we've been doing for a little over a year now, I think. It's a 3-year effort. The bulk of the grants are the monies are going to state and local courts for their pretrial improvement efforts, but we're also developing a few implementation resources along the way, and I'm going to talk about a couple of those in a minute. And we have an advisory committee that helps us decide our direction and priorities and approves technical assistance requests and our products. And we have one of our members here. I've already lost her, Marcy. And could you pronounce your name? Okay, thank you. From Hennepin County in Minnesota. And Chief Justice Barbera of Maryland is the chair of the committee. So I'm going to very briefly talk about these resources. They're not totally finished, so we had hoped to be able to debut them here for you. They're on the cusp of being finished, but yet have a few tweaks and need to be approved by the advisory committee. The first is an assessment and planning tool. There's lots of resources out there that have been developed for multidisciplinary efforts and for law enforcement and prosecutors, and there hasn't been a lot that's been focused on state courts. And so one of the tools that we decided was needed was something that would help courts get started on planning. It's a framework for guiding them through the process, assessing their system, identifying issues, deciding what they're going to work on, and then making a plan to implement change. And that will, and it also has a lot of references to all of the resources that are out there, but in a way so that folks just don't, go nuts trying to collect everything there is, but focus the resources on the things that they're trying to address. And then, Sue, could you just take a moment, because one of the things that a jurisdiction may likely want to do is decide to implement pretrial services.
Yeah, so the second resource is, it's not like a deep economic analysis telling you what exactly your costs are going to be, but what it does is it takes you through all of the things you'll need to think about if you're planning a pretrial services entity, some of which maybe you hadn't thought about. Everything from where you would house them to what type of staff you would hire.
And we expect both of these products to be available in March. And you'll be able to find them on PJI's website and ours, and then eventually SJI's. And when I say ours, I mean the Pretrial Justice Center for Courts. This website and all the resources in it was developed with a funding from the Public Welfare Foundation. And that work has ended, but we continue to update the site, and you can, when you go to it, you'll see there's a scroll that has more recent events, although that isn't real recent. But it leads you to a webinar that we did a while back. But the main thing I want to show you here is it leads into the technical assistance aspect, is that tab up there that says assistance. You want to click on that, and you will come to, that's where you will find this technical assistance request form. And I'm certainly not going to go through it, but these are some key things to note. If you are thinking about implementing reform, whether it's large or small, you'll have to complete this form and send it to me. That's that arrow there on the right. And another key thing is, because this is all a very collaborative effort, and we always want to know who's doing what in our states and local courts. If it's a local court that wants to do the work, then you have to have the chief judge or presiding judge sign it, and regardless of whether it's local or state, the state court administrator or chief justice needs to sign it, so that we know that everybody is on the same page about this effort going forward. I want to say a little bit about completing the form. Some of our efforts have been pretty straightforward, and I'll just show a list of them here. Training on pretrial risk assessment. Well, that's fairly easy to say. We'd like somebody to come, say, and talk to us about the need for using a tool or a risk-based system, and that's a more limited type of engagement. And although it can become more extensive, so a little bit later you're going to learn about Alabama's work. But it could also be more extensive, like in Georgia, they knew they needed some help on identifying best practices, and they thought they might want to have some legislation that they would put forward in time for the new legislative session, but they weren't sure how that would work out, and so, or what they would need, and so we had a series of phone calls to eventually land on what we would be doing with them. So it's not totally cut and dried. And then you can see we've sponsored conferences and site visits. The Connecticut team went to visit New Jersey and learned a lot from their counterparts there. So that kind of gives them a inspiration to come back and undertake whatever efforts they're going to do that are related to that. And two that I'm going to talk about a little bit more. The first is a longer-term effort in New Hampshire, and the second is one that's fairly new that I didn't tell you is in New Mexico. Oh, well, proofreading. So it is in New Mexico. This is a map that shows you where our assistance is going. I have noted New Hampshire and New Mexico there, so now you know it is. And then Georgia, what we'll be talking, or Alabama, which we'll be talking about later. And I can tell you that we do have some jurisdictions in the pipeline that will help fill out that map so that it's not all going to be like this coastal. I realized when I looked at it, it's like, where's the Midwest? So there are some things in the pipeline that will broaden that out a little bit. All right, so I'm going to talk about New Hampshire because it's an interesting model and that you might want to consider. We used remote technical assistance for this entire project, and it spanned 8 months, and that went from forming a committee to implementation. And that was also a fairly profound change that they were engaging in, going from largely a monetary conditions for release to a risk-based system. So that you would think would take a lot of convincing of local people that they could actually make that type of change. And I think this was one of the reasons this was successful is 2 of the members of the team participated in the fundamentals or completed PJI's Fundamentals of Pretrial Justice, which is a six-week session. And so they were already grounded in a lot of the theory and reasoning for having a risk-based system. But even then, it took a lot of work to move them along. And this, I don't have any expectation for you to be able to read what they did. But it's just to show you how complex their system was. And so over a period of, I would say we had 5 or 6 video conferences, and then in the interim, telephone calls and exchange of documents, and in order to move from what is a very basic system of bail commissioners coming down to the courthouse and deciding whether somebody gets out and how much bail they have to pay, to moving to using an evidence-based risk tool. And it took a lot of steps to get there. And I think selecting the tool and then creating a framework for decision-making were the 2 very entailed, I think, and Sue, you could probably confirm that takes a lot of work. And for them to be able to do that through video conferences is, I think, hopeful that for a smaller amount of money, you could get a lot of bang for your dollars. And that was about $10,000. The New Mexico project is expanding what is a current for about 2 or 3 years in Albuquerque, Bernalillo County. There is what's called a Metro ROR project. And under that's released on recognizance. The judges there have established written protocols so that in certain identified cases, misdemeanors and nonviolent cases, folks who work for the court intake officers can conduct the investigations, and then they can authorize the jail to release the defendant. And this has worked very well there, but New Mexico has a lot of rural counties, and in those counties, magistrate courts have that initial release decision responsibility, and they don't have the resources to do these investigations. And so this project is actually using remote technology to implement the project itself. And so what they've done is they found, well, eventually they contracted with 2 rural jurisdictions, and they've set up the video connections for long distance, video discussions with the defendant. And then what they do is they communicate with a court intake officer in Bernalillo County who is doing the investigation of all the databases, local, state, NCIC, to make the same determination that they would for a defendant who is in Bernalillo County, but they're doing it for Sandoval and Valencia counties. And so far, they've only had, they had high hopes of hiring 4 intake officers, but they were only able to recruit 1, but she is now trained and has been doing the investigations and the releases remotely. I think maybe one of the issues with that was that the position was a temporary part-time position, which would involve a lot of training and higher skills that maybe a lot of folks didn't want to take on that type of commitment for something that was temporary. But I don't think that's anything negative about the whole concept. And this really has a lot of implications for helping courts across the country with a lot of remote areas. This describes, and you can read it in your downloaded materials, what they're doing. These are contract officers, but eventually what they want to do is have the be court staff. And eventually what they would like to do is to have, and they expect that the legislature will fund this permanently. And I failed to tell you in the beginning that they have had New Mexico has had very dramatic reforms in pretrial justice already. They passed a constitutional amendment you may have heard of where the people by 87%, a huge majority, approved preventive detention for people for whom there is no set of conditions that would protect the public safety, but also no one who is eligible for release can be held just because they don't have the ability to pay for their bail amount. So I think this New Mexico project has a lot of good ideas will come of it for other states. Yes, question?
You have a quick question out of curiosity. Are the magistrates involved in the decision in New Mexico in the pilot program, or are these intake officers making the decision without
it's going to follow the same model as at the Metro Court. So the judges, the question was, are magistrates involved in the decision making? Or is it just the court intake officer? It is the court intake officer, but they have been authorized to do that by written protocols that the judges themselves have written and approved. So in a sense, they have the judge behind them. And that's a similar concept. Other jurisdictions have what's called administrative release. Kentucky has this so that their pretrial service workers can make the same type of decision to release the defendant. And now we're going to talk and hear more about Birmingham. And Bettye King's efforts there, and not just for Birmingham, but I would say for the whole state of Alabama. She's trying to bring reform.
Thank you. Thank you. I appreciate the opportunity the National Center for State Courts and PJI gave to me, allowing me to come and speak about our experiences. Let me ask a question of this audience. How many of you have received a letter or been named in a lawsuit? Not bad, not bad. When I asked that question in Alabama, 80% of the room, minimum, 80% of the room, the hands would be raised where they've either received a letter or they've had ACLU, Southern Poverty Law Center, and Equal Justice have either contacted their court or they've been sitting in their courtrooms quietly taking notes. Well, it became fairly uncomfortable for that group. So in Birmingham, we decided that we were going to take a different approach. A few years ago, we started conducting some research, trying to find the best practices. We attended any conference offered around the country. We contacted any agency that would provide assistance. And also, we asked for those entities that were suing. They were like, please come in and talk to us, sit down with us. So this effort was led by the presiding circuit judge, Judge Buhacker. In 2016, Judge Buhacker said, Bettye, can you coordinate bringing in all the municipal courts, and we'll bring in all the state courts to a conference. So we sat down in 2016 and talked about bail reform. There was a standing order issued by his office, and a similar order was issued at the municipal level. Now, this was very different from what was happening around everywhere else in the state. Nobody else was issuing orders outside of what was mandated through negotiations. Well, we said, well, now if we were able to do that type of training for them, then we want to offer it to everyone else in the state. So we conducted a municipal court summit, and we invited everybody that had received the letter, those 80 hands or 80% of the individuals of population from the municipal courts, and said, hey, listen, we're going to conduct a summit where we're going to invite everybody in and conduct training on those particular topics. As speakers, we invited the Southern Poverty Law Center, a law firm, Baker Donaldson, who has been a strong advocate in the pro bono area in dealing with mental health issues. We had some contacts there, and we invited others that said, listen, these are the issues. But what we also offered to them, we offered it to the bench, we offered it to the bar, and any other stakeholder out there, saying, come in, we want to tell you about our experiences, what's happening around the state of Alabama, what's happening in Jefferson County. In doing so, we were able to see that there were some dynamics that we had not factored in, and we call it the Ferguson effect. With the Ferguson effect, we said, okay, we need to talk about some other things, and we put those things on the table as well. So those planning and conferences entailed this municipal court summit, and all of this was free of charge. Anyone that wanted to participate, there was no cost for participation in the conference. But we did offer the continuing education for those individuals so that they had an opportunity to receive any CLEs they needed, judicial education credit that was needed, as well as certification, continuing education for our magistrates. So this was the approach we took with this effort, and the partnership was formed. The following year, we invited PJI in 2017. We invited PJI because we said, okay, there's a process out there that's better. There is a risk assessment tool that is evidence-based. Who knew? We've been using a schedule. There's a schedule that said you can use this schedule. Rule 7 in Alabama is Rule 7.2. You can use this bail schedule, and there was a financial responsibility attached to the bail schedule. Well, it's a Supreme Court rule. Surely we can use this. No, there are some constitutionally protected rights out there that we hadn't considered. We had not put people first. We had not made them the priority. In looking around this particular group, I know everybody in this group. Who's the most important person that comes before you? The one standing before you. Your customers. The people in your community. And we neglected them. We did not put their priorities first. We did not protect their due process rights. We did what we thought we knew was correct, and that's the same response I got from the magistrates and the court clerks in Alabama. Bettye, they're explaining to me, it's a rule. You're supposed to do it this way, and I'm going, that's not what the lawsuit says. What it says is that every individual has a right to bail, a constitutionally protected right to bail. And how do we go about making sure that that constitutionally protected right to bail is there and fair? Well, we need to implement some different practices. So how do you change the mindset? How do you change the mindset for anything else? My kids tell me you do a challenge. It's hashtag anything. It's a judicial challenge. We can jump in freezing water. We can make a challenge for everything else. Well, let's make it a priority and a challenge for us to change what happens in our judicial system. That's the challenge I offer to them. Let's change what we do. We don't have to receive a letter telling us to do the right thing. Doing the right thing should come just automatically. So when we talk about best practices and what we do next, we held the Municipal Court Summit. And the last one we held in 2017, we also invited Pretrial Justice Institute to come in and do some training the days before. All stakeholders. Every jurisdiction was invited to come in and see how pretrial services function. We wanted to see what it is about this risk assessment tool. How do you use it? And many times it was misconstrued as our pretrial diversion. Having to explain the dynamics of it is very different. We had to explain it to law enforcement. That's not what we're doing. We're not diverting the cases. We're just using a risk assessment tool to determine whether or not this person should be released based on public safety risk, maximizing their appearances, and how we go about handling that is to use a tool that does not factor in money. It has nothing to do with money. You're not a public safety risk because whether or not you have $1,000 or you don't have $1,000. That doesn't make you a public safety risk. It makes you a public safety risk if you have a very dynamic history or a strong history that says that you have been physically abusive to you and you've received a number of convictions. Well, we want to look at that criminal history. We want to look at the number of times you missed court to determine whether or not you're going to make an appearance in court. We want to take all those factors into consideration. In doing so, we had to have some sort of format, and that's what they offered to us. They gave us the structure and the guidelines. Sue was so generous with her time that she answered all of our questions, as unique and unusual as they are. She didn't need an interpreter for our southern drawl. But Pretrial Justice, they did some things for us that when we did develop the guidelines and the parameters for how we were going to deploy our program, they reviewed them, and if any language needed to be modified, even if it's such that we start changing the dynamics of using the terms of the defendants. They're just individuals. Right now, it's just an arrest. So we started changing our language. We started changing and partnering with others, such as the Center for Court Innovation. And we partnered with individuals that said, okay, come in, let me show you some other best practices. So these are all people that appeared at the summit. But who we also invited was the Chief Justice for the Alabama Supreme Court. Justice Stewart appeared at that same training. And during that training time, we explained to her, Chief Justice, let me share with you some of the things that we've learned. Some of the things that we think will change the lives of every citizen that encounters the judicial system. When they step onto our front porch of justice, then we should be able to welcome them and serve them in a manner that we would treat our neighbors, because they are our neighbors. So we had to treat them with that same level of respect that our next door neighbors are treated. And so she listened to us, and we asked for her support. And it always comes up, that dreaded word, how are you going to fund this? How are you going to fund this? We said, we're going to realign our resources, and we did. We have social workers in our pretrial program. We utilize social workers because we felt that social workers offered the best linkages to services. If the individual needed services from the point that they're arrested to the point where they make that first appearance, we needed someone to provide services or ensure that services were available to them. We used bond forfeiture officers. Instead of you forfeiting on bonds, got a better idea. Why don't you tell me about their history and whether or not they need to make a bond, or do we need to just release them? So we changed the dynamics of their roles. So in deploying this program, again, we looked around for our current resources, realigned them, and partnered with Jefferson County. This partnership was the first in Alabama where a county and a municipality said, we're going to do the right thing and put those services together. And that's what in essence, what we've done for Alabama. We wanted to map out a program that could be replicated anywhere in the state, whether it's a small municipality such as Harpersville, and you've heard our horror stories where they were jailing for poor. We actually shut that municipal court down. It's in a neighboring county. They've since reopened, but they've changed their practices. They had to learn a hard lesson. We weren't willing to learn the hard lesson. We were willing to do the right thing, take that hashtag judicial challenge and do it. Sue, is there any more you want to share?
Yeah, thank you. Thank you, Bettye. Does he have to switch? Yes, thank you so much, Bettye. What we're going to do next is we're going to give you all an opportunity, and I have some questions for Bettye specifically about the grant that she received from SJI and the National Center for State Courts. But I just want to point out just the extraordinary leadership you've provided. There's a couple of things you hit on. The first was being proactive instead of reactive. It can be very expensive to be reactive, as she talked about all over Alabama. Small jurisdictions that don't have extra money are being sued and having to change their practices in a reactive manner. And then the other thing that has been so wonderful about your leadership is that you use the resources that are out there. There are a lot of technical assistance resources out there, not just in pretrial justice, but in a variety of other ways. And Bettye seeks them out and really brings them to her jurisdiction. So I just want to commend her for that.
Thank you.
So I thought I'd start with, well, we'll follow up from that leadership question. So how does a court administrator or manager lead on pretrial justice? What's kind of your role in that?
Well, my role is actually I am that backseat driver. I actually, my presiding judge, Judge Andre Sparks, has been a guiding force. He's been a visionary since he arrived on our court, at our court and on the campus. We've started programs. We have every type of specialty court program that's available. We have veterans court, drug court, domestic violence court. We have bilingual court. We have gun court. We have environmental court, community court, and DUI court. All of these services are available at the lowest level, at the municipal level. That gives us an opportunity to provide services for people when they have encountered the judicial system. It's an isolated incident. They have a chance of receiving education and training to get them out of that particular cycle and move them back, migrate them back over to the developing community. We also offered, in terms of our services, and through the leadership of Judge Sparks, we have what we call a Renew program. When I spoke earlier and I mentioned the Ferguson effect, the Ferguson effect was such that when you have received a driver's license case, those barriers that were innately there, we've already handled, the renotices and those other kinds of cases. But the driver's license suspensions that we caused, that the courts had issued for those failure to appear cases that we have renoticed on, or that on the cases where an individual is received in another jurisdiction. Well, in our Renew program, what it does is that we sit down with the person, find out why their license is suspended, take them through the entire process of getting their license reinstated. And then if the person is able to get their license reinstated, then the judges will consider removing all fines, fees, and costs, because this restores the person back to where they need to be, where they're more functioning in society and able to be a more productive citizen. So that Renew program is handled by the city. The educational part of that is what we also discovered. With the GED program, we discerned that many of the individuals, the reason they didn't have a driver's license, it was a literacy issue. So we had a literacy program developed around getting your driver's license. So with the Project Renew, we see that they are able to go through the GED program and the literacy program and regain their driver's license. So back to restoring people to where we left them. We dropped them off with the suspension of the license on a minor traffic ticket. Well, the impact is that you can't get to work, you can't get to school, can't get your kids where they need to go. We live in a rural society in Alabama, so driver's licenses are important. So that was one of the things we did through leadership, is developing programs. So if there was a court order to attend any type of program, then what we did was provide the service and make it available to them. So if you can make it to the courthouse to handle any of your other business, or if you don't need to come to the courthouse, we deferred as much of that as we could as well.
Thank you. Yeah, when I was there, I remember Judge Sparks saying that the courthouse is the front porch for our community. And he didn't mean that everybody that comes into the courthouse, we're gonna, take them and give them all kinds of, court involvement. It was just, this is kind of the touch place. And from there, there's all kinds of help we can link them to. So they really have that, I think, philosophy that helps with so much of what you do. So you touched on what kind of technical assistance you received through this grant. Could you talk a little bit more in detail about the nature of that assistance?
The nature of the assistance started with with Sue being there for us to conduct the training. The brief summary she gave you all this morning is a lot more comprehensive than what we received. What we received. That particular training, it was such that when everybody walked away, we had all the stakeholders there, and again, many of them had not been exposed to pretrial services. They had no idea what the concept, how it could impact and change lives. So we had with individuals from defense counsel saying, okay, if you're going to do this with my client and you're going to have conversation with them, what impact would it have? She explained and answered all those types of questions, but explaining the concept down to the detail level that you could actually create policy, write your own policy with your individual organization around it. You had that much information available to you. Those resources could then, whatever you developed, the policies and procedures that were developed, we could share those, and she would edit, change, hold conference calls with us, and walk us through our individual processes. The flow charts, everything we needed to do to make sure that as we're going through this and you see the little hiccups, as with anything else you start new, she was able to walk us through that and say, okay, make sure that you keep this, you have that baseline of what pretrial services is supposed to do. Beyond that, ensuring that you're taking care of people, then you're able to do so.
And it was buried in there a little bit, but we had an intense, I did a 2-day site visit in Birmingham. But since then, Bettye and I have become very close, but that relationship continues. So she knows she can always pick up the phone, even though officially her grant period is over. She knows that we are a resource to her. Would you comment on, and you use technical assistance in other areas too. We have a question, go ahead.
Oh, sorry.
Question. I'd like to know what risk assessment tool Alabama uses.
We chose.
What was the process that was used to come up with that tool?
Okay. Yeah, when I spoke earlier about that research we did, we also did site visits. We took 2 delegations to DC Pretrial Services because we heard it was the premier in the country. So we took 2 separate delegations. The first one that went was our team, and when we had some newly re-elected judges, we took a second delegation to Washington, DC Pretrial Services. We ultimately selected Virginia, VPRA, Pretrial Risk Assessment Tool. In August of last year, we took a delegation to Virginia to see the tool as they rolled out their newest version and received the training at the same time that their team received training. So we've been welcomed around the country in site visits. They've been so gracious with their time and their efforts that they welcomed us, and we took advantage of these opportunities to find what was best. Reason for selecting VPRA was that Jefferson County was already going to use that, and that's the county we are housed within primarily. And University of Alabama at Birmingham has offered to be our statistician. They're collecting the stats for all of it. So when we're getting ready to validate our tool, we have that partnership with the university and Jefferson County in Birmingham. So we will have all of the data from there, and we're able to validate the tool quickly.
Yeah, that's a really great aspect that Bettye just touched on, being paired with an analyst or a university to help with your data. And I just wanted to follow up on the assessment question. If you are interested in deciding on a tool, just some things to keep in mind. The way we usually guide jurisdictions are the demographics. So there's 3 to 5 kind of high-profile tools out there that people typically choose between. So you want to look at the tool and what kind of place it was developed in, and if demographically that matches where you're at, that's a good thing. You also want to look at the questions. A couple things. The first being, does it require an interview? There's a tool that doesn't require an interview at all. You just pull the criminal history. So that may be a resource issue, or you may not have a good data system where you could pull that information. That would be a consideration. And then also you want to look at the questions and how they define some of, particularly criminal history. Your statutes, the way you define different crimes may be different enough that it's going to be hard for you to adopt some of those measures. So those are all of the things to look at.
I just wanted to add that the VPRE is also the tool that New Hampshire decided to implement.
It's an excellent tool.
And one of the reasons is it's closest, or fairly close to the tool, the public safety assessment, which everyone seems to want to have, but there's limited resources for getting it. That's going to change, and I think coming down the pike very soon, more jurisdictions will be able to use it, but New Hampshire picked that one, Virginia, because it is closest to that. And also the data that they needed to measure whether it was capturing what they needed to know and actually identifying low risk and medium and high risk folks, they had that data available.
Yeah, I would also say the VPRE, I like the tool because they have been very open about their statistical analysis of it. So it's kind of an evolving tool. They revalidate it every few years. They publish all of their results, and even though you can't really understand all the statistics, it's there for you. And then they've also validated it to not be racially, ethnically disparate, and changed the measures when they found them to be racially or ethnically disparate. So it's a very strong tool.
And it's an easily deployed tool. We were able to train team members on utilizing the tool, and it was fairly straightforward. The interview itself, it's easy. When you're setting parameters and guidelines for your scale in determining whether the person is low risk, medium risk, or high risk, particularly at a municipal level, you have to quantitate those facts that these are still misdemeanors. So you have to put it in perspective. When we say high risk at a misdemeanor level, we're probably talking about someone with a domestic violence case that has frequently had prior convictions. So it looks like they're telling us to wrap it up.
To our time. I just wanted to remind you of the resources available. There's many out there, but certainly invite you to visit the Pretrial Justice Center for Courts, and there's actually a couple different websites embedded or related for PJI, so I've given you the link to their up is the University of Pretrial, and then of course SJI, and if you have any questions, please feel free to contact one of us, and if you're very interested in getting some technical assistance, don't be shy and give us a call.
And I can't stick around for too long this morning, but I do have my card up here. If you miss me, grab a card and get in touch.
Thank you.
Thank you all.